Hello everyone. Today we will solve a few most important MCQs on our Indian Evidence Act 1872. Okay, so those who are preparing for All India Bar examination this year, this video lecture will be very helpful to you all. Okay, so without any further delay, let's start today's session. Okay, see the first question is our law of evidence is options are lex telinins, lex fori, and lex loci solutionis, and lex citus. Okay, so the correct answer would be our lex fori. Okay, so the correct answer would be our lex fori, that is law of the land. Okay, so in this case option B would be the correct answer. Court questions under Section 165 of the Evidence Act can be put to which of the following? Options are if any witness, any party, both A and B, neither A nor B. That means court question under Section 165 में जो question जाता है by the court can be put to whom? Can be put to both witness and the party. So in this case both are the correct answer. That means option C is the correct option. So in this case option C is the right answer. Okay, now move to next question. To an answer to a court question, the adverse party is options are has a right to cross examination as a matter of right, has a right to cross examination only with the permission of the court. So correct option would be option B, that is with the permission of the court. Next question. A judgment in the election petition is not one of the judgments specifically recognized by which of the following sections? Options are Section 41 of the Evidence Act, Section 42 of the Evidence Act, Section 56 of the Evidence Act, 57 of the Evidence Act. So the correct option would be option A, that is Section 41 of the Indian Evidence Act. So in this case, option A would be the correct answer. Okay, option A would be the correct answer. Now moving to next question. Next question is which section of the Indian Evidence Act was amended by the Criminal Law Amendment Act 2005? Options are Section 154, Section 118, Section 100, Section 132, Section 190A. So the correct option would be option A, that is 154, Section 152, which is all about hostile witness. Which is all about hostile witness. Okay, hostile witness. So in this case option A would be the correct answer. Okay, now on to next question. Next question. What essential change was made in Section 154 of the Indian Evidence Act Wide Criminal Law Amendment Act 2005? So the correct option would be that option B, that the party is entitled to rely on any part of the evidence of the witness to whom he has called to put any question to him, which might be put in cross examination by adverse party. Okay, so now on the next question. Next question is a confession to be inadmissible under Section 25 of the Evidence Act must relate, which are the first options? Must relate to the same crime for which offender is charged, may relate to the same crime for which offender is charged, must relate to another crime, none of the above. Okay, so the correct option would be, I think, may relate to the same crime हो सकता है for which the offender is charged. So in this case option B would be the correct answer. So now on to the next question. The provision hostile witness is provided under section of the Indian Evidence Act. Options are Section 155, Section 133, Section 154, Section 145. Okay, so the correct option would be option C, that is Section 154. So Section 154 has laid down the provision regarding hostile witness. hostile witness. Okay, so in this case, option C would be the correct answer. So now on to next question. Next question is, in which section of the Indian Evidence Act presumption as to dowry death is provided? Options are Section 111A, Section 111B, Section 113A, Section 113B. So the correct option would be option D, that is Section 113B. Okay, has laid down the provision regarding what presumption as to dowry death. Dowry, dowry death. Okay, now on to next question. Next question is, Section 114A of the Indian Evidence Act is related to which of the following? Options are presumption as to abatement of suicide by married women, presumption as to the absence of consent in certain prosecution for rape, presumption as to abatement of suicide by women, none of the above. So the correct option would be our option B. That means Section 144 has laid down the provision regarding presumption as to the absence of consent. Okay, in certain prosecution of rape. So in this case, option B would be the correct answer. Now on to next question. Next question is, under which of the following sections of the Indian Evidence Act opinion as to the handwriting has been considered to be relevant? Options are Section 100, Section 47, Section 48, Section 53A, Section 56. So the correct option would be our Section A, that is Section 47 of the Indian Evidence Act. So in this case, correct option would be option A. Now on to next question. Next question is, which of the following section of Indian Evidence Act 1872 contains provision regarding cross-examination and re-examination witness character? Options are Section 142, Section 140, Section 139, Section 141. So correct option would be option B, that is Section 141. So here the correct option would be option B. So now on to next question. This is the next question and the last question. Okay. Uh, which of the following is not correctly matched? Okay. Options are hostile witness, Section 154. This is correct. Burden of proof as to ownership, Section 110. This is also correct. Refreshing memory, Section 139. This is also correct. Professional communication, Section 124. This is incorrect. Okay. That is, professional communication has been defined under section which? Under Section 126 of the Indian Evidence Act. So, so the correct option would be option D. Okay, option D. So in this case, the correct option would be option D. So this is for all today. If you liked this lecture, please like this video and subscribe this channel. Okay. In this video, I have already started MCQs on various MCQs on Constitution, CRPC, BNS, BNSS, and so on. So if you don't want to miss any of this lecture, please subscribe this channel. Okay. Thank you. Thank